Welcome everyone to our Legal Tuesdays. We are with Kelly, our favorite attorney, and today we're going to be discussing about partnerships. The not to do partnerships. I was telling Kelly earlier before the segment started, the partnerships are not even included in my segments when I'm talking about legal entities because of the complexity, not of the situation, but of the people involved in those partnerships. But from the legal perspective, we wanted to get Kelly's point of view, legal perspective on how those things work. So welcome, Kelly. Nice to have you on the show again. Months go by really fast, don't they?
They certainly do, Joe. Yes, and thank you so much for having me again. And what a wonderful topic to discuss. But before we go into that discussion, as always, there is a disclaimer. Any information that I share here on the show is only for informational purposes, and it does not create an attorney-client relationship at all. Any of your listeners are more than welcome to reach out to me or to you directly, and I'll be happy to answer any of their questions.
Excellent. Well, thank you, Kelly. And also, if you don't mind, I like when you do your self-introduction. So tell us who you are, a little bit your brief bio before we start.
Perfect. I have been given the name the Queen of Business Law, Joe.
Well deserved.
Thank you. And it is affectionately given to me by clients because the queen is the most powerful piece on the chessboard and she can move either which way. And her only job is to make sure that she protects the king. And in my case, is protecting my clients.
Nice.
And I have been a practicing attorney for about 17 years now. I've had my own firm, Bagler Law Firm, for about 11 years. I've loved every moment of it. And what makes me different, Joe, from other lawyers out there is that I'm not just a lawyer, I'm also an entrepreneur as well. So I do have other businesses and I can relate to each and every startup, every entrepreneur, every business owner that's starting or growing their business. I've gone through the same struggles. So that's the perspective that I bring to the table when I talk to clients that are looking to incorporate or draft contracts or even do some asset protection.
And you're totally right. And I'm being your client in the chamber has been your client for a while. And I totally confirm and attest your description. You've been the best attorney I met with, who's been able to break down the components, the legal components, to an understandable way, conversational language that makes sense. So, because as in business, liability is huge, and yes, we want to work with someone like you as an attorney, but our main focus is to make sure that we don't get to that point, to helping us before that happens, with how to navigate the path of legalities. So let's dive in, Kelly. Let's dive into the partnership. So by definition, what is a partnership?
A partnership is any combination of two or more individuals that go into business. So two or more individuals, that usually creates a partnership. However, there are different definitions under the law. You can actually incorporate as a limited liability partnership. That's an incorporation, an incorporated entity. But if you just want to go into a partnership, meaning there's just going to be a partnership agreement between two parties, then you have to make sure that you really spend a lot of time thinking about the duties of each partner, what each partner is bringing to the table, and how are they going to fulfill their duties. So in the past month or so, Joe, I've had at least two cases where there's been two individuals that have gone into partnership. One is pertaining to a CPR course. So it's a class. They teach a CPR class to individuals that actually want to go into nursing or become nursing aides. So they teach a CPR class. One of them is doing, and they had a partnership agreement in
Mhm.
place. And one of them is teaching all the classes. She created the curriculum. And the other one is sort of running the technical side of things, if you will. So he invested some money into this by purchasing the products. Now, it's really, really important. I cannot stress enough. Spend time with the individual, because once you go into a partnership with someone, it's more difficult than actually divorcing a spouse.
I bet.
And this can really harm you financially as well. So in this partnership where you've got the teacher teaching the course, and then you've got the other person doing the technical stuff, well, there was a lot of, as they started going into business, within a month or so, very quickly, they did incorporate. However, they incorporated by themselves, which means that they didn't have any internal documents. Stock wasn't issued properly, but yet they were both 50-50 partners. And they were supposed to make 50-50. They were supposed to make decisions together, and it shouldn't be solo. But in this case, one of them was making all the decisions, and the other one kept saying, well, we have a partnership agreement, and you're breaching all of that. And it's, again, I cannot stress enough, do your due diligence on the individual that you're going to go into a partnership with. Don't just have a partnership agreement. Really spend some time writing down each other's duties, because now it's, you're supposed to be doing this and not me, or it's, no, you're supposed to be doing this and not me. And the person that's getting hurt is the student that is wanting to take the class, but yet the class is not available because it wasn't scheduled properly, and there's no oversight to what's going on. Now they want to amicably separate from the partnership. Well, because it's 50-50, one of them cannot just go out and file a dissolution of the corporation. To make things worse, they went ahead and tried to amend the articles to change it into a non-profit. So now they're in limbo. They literally are in limbo. They have no idea whether it's still a for-profit or is it a non-profit, because when you dissolve, especially a nonprofit, you don't dissolve as a regular company. All the assets of your company, they don't get sold back to you. You don't get anything for them. They have to transfer to another similar nonprofit as yours. So there's a lot of money involved. There's a lot of assets involved, and they have no clue what they're doing. So the moral of this story is, if you're going to go into a partnership, highly, highly recommend both partners get your own lawyers. Get your own lawyers and write everything down. It's going to save you headache, and it's going to save you financially in the long run. In that case, however, we decided that because the IRS hasn't approved any of the nonprofit status, that it's still a for-profit company, but yet in order for one to dissolve, he has to buy the other one out. And whatever that buyout is going to look like, he's going to do it, because this is so stressful and it's painful, and they're losing money every single time. Every day they're losing money. But this is a very expensive lesson for individuals to learn. Don't just go into a partnership with a single partnership agreement. Make sure that it's been viewed at least by each of your attorneys. It's very important. The other situation, Joe, that I had was two partners again. They decided to create a shell LLC. So this shell LLC would only be responsible for receiving money from third parties. So they both had their own individual LLCs, but yet they created this shell. And for the longest part, they've been in business for 10 years. For the longest time, the way business was ran was that whatever percentage would come in from the services, that they would get a share of that. So a split of that would go to his company, and a split of that would go to her company. However, there were other services involved where the individual themselves can actually perform those services on an hourly basis. Long story short, a very massive contract was gained by one of the partners. The commission split never changed, but yet the services part changed. So there was a lot more money coming in for the individual that brought in the deal. Now, this is where greed raises its ugly head. It's always money, right?
Always, of course.
So because this commission split wasn't written down in writing, even though we can prove that this is the way the business was conducted for over 10 years, all of a sudden now, one of the partners is saying, I want 50-50 rather than whatever the split was. And plus, I want this 50% for the remainder of the term of the deal. And at the same time, this client is busy in dealing with this big, massive contract. At the same time, you have this other client who wants 50%, but yeah, he's contributing absolutely nothing to the company. So now you have stress where you have to deal with this multi-million-dollar company and all of their counterparts. At the same time, you're trying to deal with your partner who's not contributing anything, but yet has got attorneys involved and is literally trying to take you for 50% of everything that you're making, which was never, ever, ever the decision made between the partners. Again, definitely have a partnership agreement in place, reviewed and drafted by attorneys, because they know the terms. And that way you can point exactly to the partnership agreement and say, this is exactly what we decided, and it wasn't that. That way, the situation doesn't escalate to lawsuits. And now we're sitting literally at the doorstep of a lawsuit.
Right.
So please, if you are going into a partnership, you definitely need two agreements. One is the partnership agreement, and the other one has to be a buy-sell agreement. Has to be. What happens if one of the partners in this relationship becomes incapacitated? What happens if they get hit by a bus? Right? What's going to happen to their shares? What's going to happen to the profit that's coming in? What's going to happen to all the work that they were responsible for? And they're unable to complete it now. So that's why you definitely need a buy-sell agreement as well.
Wow. So that one, especially the last one, sounds extremely complicated. And you know, just as a thought, because what I'm thinking is like they decided to do their own LLC, bring a third LLC to receive the funds. So they were doing things correctly. But as you said, greed on one of the part of the partners is coming out. So because that was probably totally unexpected, that was a really, you know, I call those blind spots.
Yes.
So totally blind spot, not totally unexpected. So in situations like that, what would you suggest to prepare for those blind spots? What would be a good alternate or suggestion that should be included in the agreement? Because this one sounds more like a venture, like a co-venture on their part, right?
Absolutely, yes. So these two individuals had known each other for a little while. They had worked together, and then that's when they decided, okay, well, we can actually create a real business here for everyone involved. But yet we'll have the one holding company, if you will, the shell company that will receive all the money. So it'll come into one spot, and then it gets distributed according to the commissions that everybody gets.
Right.
Now, one thing, and I completely understand that it's difficult. It's difficult to think about all the situations that could arise, and nobody can actually do that.
Right.
So I think if someone's in this situation, every contract that they bring in, maybe they need to have a one-page written agreement as to how that commission is going to be split.
For each particular contract.
Exactly.
Right.
And it doesn't matter which business partner brings in that contract. And it was never based on which business partner brings in the contract. It was always based on a contract will come in, a commission split would be split between the partners, and whatever percentages that they had agreed upon initially, that's exactly what they were doing for 10 years, Joe, for 10 years.
Yeah.
And then obviously, like we said, greed, popped its head up. And in those situations, when you know there's going to be a big contract, I think at those times, just before signing the contract, you do need to actually have something in writing to say, look, well, this is how we're going to split the commissions. That's one way of mitigating a potential lawsuit.
Because you're right, Kelly. And I was thinking about this, like, there's no way. I mean, going through the things that I've gone through and stuff, there is no way I can predict all the different blind spots along the way. That's why they're blind spots.
Exactly.
But preparing like the exit strategy, preparing for they call it one time off contract. So every time there is a transaction, so taking general steps to prevent stuff like that is crucial. So that's a great advice, Kelly. That's really great advice.
Absolutely.
Anything else?
And for our next show, Joe, I would really like to talk about community property. Right? That's an interesting one, especially when it comes to business, because I've just come across a situation where you have a dad that had a business with his previous wife. He has a daughter that's been involved in the business. And now the new wife has come along and now she wants part of the business and she wants her name on all of the assets as well. Well, how does one exactly? How does one handle this, especially when you have adult kids working in the business?
I stand corrected. I thought partnerships were the worst, but no, this would be a really horrible situation. So, and again, how did you prepare for that? So,
right.
Yes, I think that's a great topic for our next segment. And as we'd like to tell the audience that we want to be putting our segment into the national radio show. So starting either in October or November, we don't know yet. You and I we'll discuss that. But this is a great topic to get us on our first show in that segment. This is an awesome topic.
Excellent. Yes.
Interesting and awesome. Well, and so one of the questions that always comes up is like, instead of creating a partnership, of course, there's no 100% protection, but instead of creating a general partnership, which those are horribly, in general partner and limited liability partnerships are so complex because the federally regulated, so kind of don't want that. But so a limited liability company could be a good option for instead of the general partnership. Would you agree?
Absolutely, because with a general partnership, you always have the general partner, the head partner, he or she will be personally liable for all the debts. Same thing with a limited liability partnership. The partner, the general partner in a limited liability partnership will be responsible for the debt. Now, how can you, being a savvy business owner, go into a partnership with someone knowing that there could be debt which you personally would be responsible for? You can't do that. So generally, from a legality standpoint, I don't like general partnerships. I don't like a limited liability partnership. If anyone can avoid that type of legal structure, definitely avoid it. You have S corporations, C corporations, you've even got limited liability companies. And in all three of those situations, if the officers remain within their corporate authority, then all the debt that the corporation will accumulate belongs to the corporation and not the officers personally.
Yes, I totally agree with you. I totally agree. And that's a great advice because I have no idea how many people I come across when I'm doing my classes on entrepreneurship and how to start a business. I repeat what you just said. It's like, no partnerships, please. No partnerships. So find other way. Yes. And in this case, find other way that is, but definitely no partnerships.
Exactly. And Joe, I can't stress enough, and I think I've shared this with you and your audience and the listeners over and over and over again, because it's this important. Anytime you are incorporating a business, make sure that you have the internal documents. So for example, everything that the last partnership that I just spoke about, that they had created the shell company, one of the partners, he went out and formed the company by himself. He went off and he filed the articles online, and that was it. There were no internal documents. There wasn't an operating agreement involved. There wasn't any partnership agreements involved, nothing at all. And so when it really came down to it, because the operating agreement in that situation would really dictate and say, okay, this is the commission split. This is what we agreed upon.
Right.
That would be included in the operating agreement. Here, they didn't have any. And this is 10 years later, for God's sake.
Wow.
So now it's going to cost him, 5, 6, 7 times more trying to defend this, when they could have simply have just put this in the agreement and said, look, let's point to the agreement. And it's very important that you have internal documents, such as bylaws, such as operating agreements. And if you don't, you will get sued personally.
Oh my goodness, yes. Because then you're running the company as your personal entity.
There you go.
Yes, absolutely.
You know a thing or two,
Oh,
Joe.
A few things that I learned from you, Kelly. I do keep my ears open.
That's
Yes.
sweet.
Well, thank you very much, Kelly. I really appreciate it. This segments go really fast, but again, we'll definitely cover that topic in our next session. And so I think it's a very interesting topic. And again, thank you very much for taking the time to talk to us about this legality stuff.
Yes.
And looking forward to our next session.
Thank you so much.
Again, how do people get in contact with you? Please say it again.
Yes, they can either email me, kelly@baglerlaw.com, or they can call me directly at 760-579-6789. And that sort of reminds me of a quick joke. Joe, I have to share that with you. So
Okay.
why was 6 afraid of 7?
Why is 6 afraid of 7?
Because 7, 8, 9.
Oh, that's a good one. That's what they call a daddy joke, a mama joke.
It is. I remember my nieces told me that
Oh my
ages
gosh.
ago. So it stuck with me. So that's how people can remember my phone number, right? 760-579-6789.
6, 7, 8, 9.
Yeah.
Excellent. Good point. I will never forget your number.
There you go. Thank you, Joe, for having me.
Thank you, Kelly. Looking forward to the next one.
Likewise.